Welcome everyone to our annual preview of the coming Supreme Court term. I'm Irv Gornstein, Executive Director of the Supreme Court Institute. As is customary, I begin the program with a few observations of my own. Not since Bush against Gore has the public perception of the court's legitimacy seemed so seriously threatened. It is not only the Chief Justice who has felt the need to say we do not have Obama judges and Trump judges. We have also seen Justices Breyer, Barrett, and Thomas in rapid succession make public statements that differences in judicial philosophies, not partisan affiliation, explain the results of the court's most controversial decisions. I think we may have come to a turning point. If within a span of 2 to 3 terms, we see sweeping right side decisions over left side dissents on every one of the most politically divisive issue of our time, voting, guns, abortion, religion, affirmative action, the perception of the court may be permanently altered. It is all well and good for justices to tell the public that their decisions reflect their judicial philosophies, not their partisan affiliation. But if right side judicial philosophies always produce results favored by Republicans, and left side judicial philosophies always produce results favored by Democrats, there is little chance of persuading the public there is a difference between the two. And if justices think the usual number of unanimous decisions and a few votes against type in cases that most of the public doesn't care about will counter that impression, I think they may be deluding themselves. The conditions for the right side running the table have never looked better. In every term besides the last, one right side justice was all it took to slow down and occasionally reverse the march to the right, and that's no longer true. But I don't think sweeping right side rulings in all politically salient cases is inevitable. Last term, we saw there may be 3 on the right, the Chief Justice, Justice Kavanaugh, and Justice Barrett, and 3 on the left, Justices Breyer, Sotomayor, and Kagan, who are interested in reaching common ground if and when they can. We saw that in Fulton, where those 6 justices ruled narrowly for the Catholic Social Services. We saw it in California against Texas, where the same 6 effectively put an end to challenges to the Affordable Care Act. And we saw it in Arlene's Flowers, where the same 6 voted to deny certiorari on a case involving religious objections to serving gay weddings. The huge question mark for this term and next is whether the same 6 can find common ground in any of the coming controversial cases. With me to discuss the coming term is a panel of exceptionally gifted Supreme Court advocates and observers. Because you are all familiar with them and their achievements, I will make the introductions brief. We have Roman Martinez from Latham and Watkins, Paul Smith from Georgetown Law, Nicole Saharsky from Mayer Brown, and Jeff Wall from Sullivan and Cromwell. Here's how we'll proceed. I will call on one of our panelists to present a case. When the presentation is complete, I will then ask other panelists to share any thoughts they have on that case. And then we'll do the same thing again until we get to the end of our presentations. At that point, I will ask the press to ask any questions they may have on any of the cases. First up is Roman. He has New York Rifle and Pistol Association versus Bruin. You're muted, Roman.
Thank you. Thanks for the heads up. Irv, thank you for having me again, and thanks to the Georgetown Institute and my fellow panelists. It's great to be with everyone, especially as we look ahead to what is likely to be an eventful term. As Irv said, I'm going to talk today a little bit about the New York State Rifle and Pistol Association versus Bruin case, which is shaping up to be a major fight over the scope of the Second Amendment right to keep and bear arms. Let me start with just a little bit of background on the case. As everyone will remember, in 2008, the Supreme Court decided District of Columbia versus Heller, which established that the Second Amendment protects an individual right to possess and carry weapons for self-defense. And it applied that right to strike down a DC law that banned handgun possession in the home. A couple of years later, in 2010, the court decided McDonald versus City of Chicago, which held that the Second Amendment right is incorporated against and applies against the states, not just against the federal government. Since then, though, the court has not decided another Second Amendment case on the merits. The closest it came was a couple of terms ago when it was set to address a New York statute banning individuals from transporting lawfully owned guns to firing ranges outside the city. So the law affected sort of the transport of the guns. New York, though, repealed that statute while the case was pending, and the justices eventually dismissed the case as moot without reaching the merits. But the court's lack of activity in the Second Amendment area since Heller has not been because there's been a lack of litigation in the lower courts. According to one of the amici in the Brewing case that I'm going to talk about, there have been about 1,500 or so cases filed that involve challenges under the Second Amendment to federal, state, or local gun laws across the country. And so the lower courts have been left to wrestle with many of the issues that were left unresolved in the Supreme Court's Heller decision and in the McDonald decision. And two issues have been especially sort of challenging for courts. First is a methodological one. Courts have wrestled with what legal test should be used to assess whether a particular gun regulation is lawful. In many other areas of constitutional law, the court has established tiers of scrutiny. We talk about them as strict scrutiny, intermediate scrutiny, et cetera, that at a very general level basically allow government entities to pass laws that restrict certain constitutional rights so long as they have a really good reason, and so long as the restriction on the right is appropriately tailored to achieve the government's legitimate purpose without prohibiting, infringing more of the right than necessary. And the court has basically held that a more demanding level of scrutiny is needed when a restriction impinges on the core of the constitutional right at issue. So courts have had to wrestle with whether this same kind of tiers of scrutiny approach applies to the Second Amendment. Heller didn't say anything on this point, but the courts of appeals have generally carried over that tiers of scrutiny approach into the Second Amendment context. They've said that strict scrutiny applies if a regulation burdens the core of the Second Amendment, but something closer to intermediate scrutiny applies if a state or federal restriction implicates non-core Second Amendment rights. And obviously, there's a lot of confusion and perhaps disagreement about what counts as being within the core. The second issue courts have often had to wrestle with, or a second issue courts have often had to wrestle with after Heller, is the language in Heller that seemed to limit the scope of the holding. Heller was very clear that the Second Amendment is not unlimited and that certain types of historical limits on the right to bear arms are presumptively lawful. That's the phrase it used, presumptively lawful. And Heller gave a number of examples. It talked about bans on carrying concealed weapons, bans on possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in certain especially sensitive places like schools and government buildings, and then also laws sort of regulating the commercial sale of guns. So these examples, which the Supreme Court said were non-exhaustive, suggested that maybe that the Second Amendment right is not just sort of, even though there are not a lot of details provided in the constitutional text, suggested that the Second Amendment right, individual right to keep and bear arms, is not unlimited, but rather is limited by certain sort of historical or longstanding types of prohibitions that we can get from our history. And courts have have disagreed about how to apply these principles to state regulations of various sorts, including, as we'll see in this case, state regulations on carrying weapons outside the home. So that really brings us to this case. The New York State rifle case really gives the court an opportunity to weigh in on some of the methodological questions, but also to address the question of whether and how the Second Amendment governs claims that individuals have to have a right to bear arms, to carry arms outside of their home. as I said earlier, the Heller case involved the right to keep and bear arms for self-defense inside the home. So the case involves a challenge to a New York statute that requires a special license to carry a handgun for self-defense outside the home. And specifically, the law says that a person who wants to carry such a handgun has to establish to the satisfaction of local authorities that they have, quote, proper cause for doing so. New York is one of about 7 states that have this kind of special justification or proper cause type requirement to have permission to carry a handgun outside of the home. The plaintiffs in the case are 2 individuals and the New York State Rifle and Pistol Association. The 2 individuals have licenses to possess weapons inside New York. They can carry those weapons. They can keep the weapons inside the home. They can carry the weapons outside the home for hunting and target shooting, but they're not allowed under the terms of those licenses to carry their weapons outside the home for purposes of self-defense. And the New York authorities said that they could not satisfy the proper cause requirement to get that kind of permission because New York concluded that they don't face any special or unique danger to their life above and beyond the dangers felt by just any other ordinary citizens. So these plaintiffs joined together. They sued New York in federal court for declaratory and injunctive relief that would hold the New York statute unconstitutional. The district court and the Second Circuit, the district court rejected that challenge and the Second Circuit affirmed. Second Circuit held that although the Second Amendment applies to, covers the public possession of firearms, this is outside the core of the right, and therefore it applied a version of intermediate scrutiny and upheld the law based on the state's justifications that this kind of law is necessary to protect public safety. So now the parties are in the Supreme Court, and the challengers raise a series of arguments for why the Second Amendment gives full protection to the right to carry their guns outside the home for self-defense. They make a couple of points. I'll just summarize them very quickly. They point to the text of the Second Amendment, which talks about the right not just to keep arms, but also to bear arms. And they say that bearing arms means carrying arms, and that that's most naturally understood to refer to carrying arms outside the home. People don't really talk about bearing arms like inside their living room. The challengers talk about the purpose of the Second Amendment. They note that the Heller decision emphasized that self-defense is at the core of the Second Amendment, and they point out that the need for self-defense arises not just in the home, but also outside the home. They point to history and tradition. The challengers say that the right to carry arms has long encompassed the right to carry them outside the home, although they concede, and this is important, they concede that historically there have been exceptions to that right to carry outside the home for what they say are circumstances in which you want to carry an unusual or especially dangerous weapon with the intent to terrorize the public. On the level of scrutiny question, the challengers essentially say that you don't need to apply any particular level of scrutiny, that basically because this carrying guns for self-defense outside the home is protected by history and tradition, that's enough. And the Second Amendment doesn't require you to go further than that. But if tiers of scrutiny apply, they say this is a core to the Second Amendment right, and so strict scrutiny should be the lens through which to analyze the statute. The state, on the other side, responds with a series of arguments. Interestingly, they don't challenge the core argument that the core point that the Second Amendment protects the right to carry guns outside the home. Instead, they take a narrower view, and they say that, and here I'm quoting from their brief, any right to bear arms outside the home permits a state to condition handgun carrying in areas frequented by the general public on a showing of a non-speculative need for armed self-defense in those areas. So they're basically saying that the state has a right to regulate when you're going into areas that are frequented by the general public. They're not making the broader argument that the state can necessarily regulate every single, everywhere. The basic historical pitch that the state makes turns on a close reading of many historical statutes from England, from the common law principles, and then also statutes from the founding era in the 19th century. They go back to the 1328 Statute of Northampton, which I was not especially familiar with before looking at this case. the state makes the argument that there's no Anglo-American jurisdiction in the last 700 years that has maintained a public carry regime that would let people carry handguns wherever and whenever they want, which they say is what the petitioners are asking for. Instead, they say that these historical statutes and the common law and the statutes as they continued into 19th and 20th century America have allowed governments to limit the public carrying of weapons, especially in public places, in crowded places. And they say there's a distinction between those kind of public places that might be crowded and usually where you can expect law enforcement to have at least some presence, from places like the countryside, or when people in the old days were taking long travels on roads that weren't especially well guarded. The state says that points out that these historical statutes often regulated carrying guns in sensitive places where people tend to congregate and where public safety professionals are usually available. And they challenge the petitioner's argument that these historical gun laws really were limited just to circumstances involving unusually dangerous guns that were being brandished to terrorize people. On the level of scrutiny question, the state says that if a history and tradition test applies exclusively and there's no tiers of scrutiny, they say that doesn't matter because they can win on history and tradition, but they seem to make a stronger pitch to argue that really intermediate scrutiny should apply here. And so that is the basic sort of overview of the arguments. I'm not going to make a prediction as to how the case is going to come out. I'll leave that to my panelists, my fellow panelists, to make very strong predictions about all their cases. But let me just offer in closing a couple of quick sort of observations about the case. First of all, it's interesting that the bulk of the briefing on both sides so far, we haven't seen the reply brief from the petitioners yet, but the bulk of the briefing so far really addresses and does a very deep dive on the historical arguments about what exactly are the historical limits on what the state can do what government entities have done to place regulations on carrying guns publicly outside the home. And the most of the briefing focuses on that. But in some ways, the methodological question of how courts and how the justices need to analyze these Second Amendment rights are equally important, and maybe even more important in terms of the spillover effects of this case for future cases. The Second Amendment is unlike other the Second Amendment individual right to bear arms is unlike other individual constitutional rights in that it's sort of a younger vintage. It's a more recent vintage. It's been recognized more recently, and so it doesn't have the same kind of doctrine built up around it. And so there is this question about whether the strict scrutiny, intermediate scrutiny, tiers of scrutiny analysis should apply here. Heller left that open. And some of the justices in recent years have expressed sort of some discomfort with the level of scrutiny approach in other contexts. And two of the justices currently on the court, Justices Kavanaugh and Barrett, when they were on the courts of appeals, they dealt with Second Amendment issues in a couple of different contexts. And in those opinions, both of them, and especially Justice Kavanaugh, seem to reject the idea that a tiers of scrutiny should approach should apply. And instead, they seem to say that the real test should just focus on history and tradition. And that if there hasn't been a history or tradition of regulating, imposing a certain type of regulation, then that regulation is, basically invalid. That kind of approach is potentially has very significant implications outside of this particular case. There seems to be as I'll get to in a sec, there's a robust debate about the history and tradition, but you can imagine a lot of other gun control, gun restriction provisions of law that are out there that don't have clear historical analogs, and those might be more vulnerable, arguably, under a history and tradition approach. It is interesting, though, to note that in Justice Kavanaugh's dissenting opinion in a DC Circuit case where he talked about this, he actually said the opposite. He said that at that time, at least, that he thought that the looking to history and tradition approach instead of the applying, strict scrutiny or the tiers of scrutiny approach, he said that looking to history and tradition might actually protect the ability of states and federal governments to impose more restrictions on gun rights. And he emphasized in particular the fact that the examples that Heller gave of the presumptively lawful historical restrictions on gun ownership, those might be things that couldn't survive a strict scrutiny approach, but could survive a history and tradition test. So I think it'll be interesting to see what the justices say methodologically. Secondly, with respect to the historical arguments, it strikes me that there's a real fight here. This is not the kind of case where one side has all the history on its side and the other side is sort of appealing to broader purposes or even to the text. I think both sides make very substantial historical arguments. I'd be very interested to see what the petitioners have to say in response to the points that the state has made, because the state actually puts forward a lot of evidence showing that that really there were these restrictions on the right to carry arms outside of the home. And I think there's a lot of very technical in the weeds historical debate about exactly how those restrictions were interpreted. Are they limited to circumstances in which people are kind of brandishing weapons and trying to terrorize the population? Or are they actually broader than that? And do they allow the state to restrict people just from carrying guns without doing anything particularly threatening other than simply carrying the weapon? I think that the justices, like your panelists here, are going to know a lot more about the statute of Northampton by the end of the time when they finish dealing with this case. And I think they'll look at that and all the other, they'll have to do a deep dive into the historical statutes. And then the final comment, I do think that we tend to think rightly of the Second Amendment as being something that's politically contentious and that has divided people on the court. And I certainly think it's possible that and probably likely that this court will see some of those traditional divisions. But it also seems to me that the strength of New York's historical counterarguments suggests that this case could actually be one that's a little harder than we might initially guess. I think that on the methodological question, you're more likely to get the conservatives rallying around a history and tradition approach. But on the question of how you apply that approach to these particular facts, I do think there's going to have to be some hard historical work that's done to figure out exactly what the scope of those pre-existing rules were. I also think it's notable that Judge Bybee on the Ninth Circuit, who was a conservative judge appointed by President Bush, Judge Ludig, who was a former judge appointed by the first President Bush, but now retired from the bench, but seen as a rock-ribbed conservative. Both of them have said that they think the historical evidence shows that these kinds of state restrictions are allowed, and Judge Ludig, in fact, filed an amicus brief along those lines. So I will stop there, but it'll be a very interesting case to see, to sort of test how originalism should apply to the Second Amendment.
Thanks, Ramon. Other panelists?
It seems like with the highly discretionary New York State good cause requirement, that the justices are going to be pushed to treat this as almost the equivalent of a ban of carrying outside the home. And so if they do that, they can say, well, that clearly goes too far, without saying a heck of a lot about where the line is short of that. And that seems to me to be the likely outcome, that at least there'll be a number of justices who acknowledge this you can't really have treat it as a constitutional right and say you have to go to the state and get permission to exercise it. But that what exactly can be carried and where and all of that is for future cases. Just my thoughts.
Anyone else?
Just one quick thing in response to that. I think that's a very interesting point, Paul. And we've all seen cases that are billed as like the big constitutional case of the term, and then they kind of get decided on these narrower grounds that leave the fight for later. We've seen that over and over again in recent years. I do wonder whether that's what they would do here. I feel like on the conservative side or the Republican appointed side of the court, I feel like there's a lot of frustration that the court has not clarified the Second Amendment in a lot of, they've had a lot of opportunities to do so after Heller and McDonald. They haven't done so. Justice Kavanaugh, who agreed that the case 2 years ago was moot, even in his concurrence there said, we really need to sort some of this out. I hope another person brings a case up. So my sort of guess would be that even if they can decide this particular statute narrowly, I think they will want to say something more broadly about the methodological question, just to kind of provide some guidance to lower courts. I think there are probably at least 5 votes that want to say something here, but we'll have to see. And it's a great point.
I think the interesting question is just what they say. I mean, to the extent that the challengers to the law are suggesting, almost no limits on public carry. I mean, the court itself has said that there are some laws that are presumptively constitutional, including, I think they suggested public carrying in sensitive places. You can imagine what they think about courthouses, et cetera. And so if that's the going in, maybe they think that the New York law is just too discretionary, and that's a reason to rule in this case. But providing more guidance in terms of what the limits are, seems incredibly challenging to me, especially in light of the historical record, which seems to show a lot of historical limitations in place. So it'll be interesting to watch.
Yeah, look, I'm with Paul. If it were more targeted, I think Nicole's right. I mean, if it were not near libraries and not near schools and all the rest, but a discretionary regime where it's virtually possible, extremely difficult to get the state's or the city's permission in order to carry outside the home is unlikely to survive. And then, as Ramon says, what are they going to say methodologically? And I tend to think they will want to say something, and that's probably where the case ends. I just think it's going to be tough for the state, given that it hasn't tailored its regime more than it has.
I think
So I
the
wonder,
question about
go ahead.
Sorry, I actually was going to pose a question to you, Irv, which is this methodology question is super interesting because, you know, I'm not really aware of other constitutional rights where there's, at least the way the petitioners and respondents have treated it, is you do a historical analysis and then go to levels of scrutiny. That was how I read their briefs, and that seemed to be what the courts of appeals who address public carry laws were also doing. And that seems to me to be a pretty novel approach. So I was actually interested to hear what you thought about that.
So I guess how I understand the historical approach is one that's completely distinct from standards of review. And so the text refers to the right to keep and bear arms. And I think what some people would say is, in order to understand what the right is, we have to look to history. And the right may be qualified by, you know, it's a qualified right. It's not an absolute right. But to understand the scope of it, we simply look to history. That's how I understand it. And once you're done with that, the case is over. Now, I wonder what people think about whether the court is going to commit itself to that, because this is the question I raised. Where does the sensitive places carve out come from? I don't think the court said that was coming from history. And is the court really going to commit itself to a historical approach if that ends up being inconsistent with sensitive places? So what about, you know, train stations? What about metro stops, subways? What about bars? What about nightclubs? What about restaurants? Places where, you know, they're not historically grounded, but you feel like there's what especially sensitive area is an especially dangerous place for guns to be unregulated. And so I wonder if anybody has any thoughts about that, how you merge the historical approach with perhaps some appeal to New York's idea that in crowded places, there should be more room for gun regulation, and in places where safety is more seems more preeminent of a concern.
I mean, it seems like from the briefing, I think that people would try to. I think the justices would have enough to work with if they wanted to square the sensitive places idea with sort of historical examples of places that where there more restrictions have been allowed. I don't think that's going to be the problem as much as I do think you're going to have an analogy problem, which is that, you know, you're going to have new types of sensitive places that didn't historically exist. I think one of the amicus briefs points to like airplanes. And so you're going to, and I think Justice Kavanaugh's noted this in his opinion in the DC Circuit, even when you're applying the historical approach, it's perfectly legitimate to draw analogies to more modern sort of situations. The danger, of course, is that some of the objectivity that's a feature of the historical approach sort of goes away once you start allowing analogies to be drawn, because I think then that sort of opens the door and makes it easier for people to analogize in ways that are not quite as objective or grounded in the history. And so I think that would be, you know, that would be a challenge to, I think, applying that approach if they go in that direction. But I do think there's an answer within that approach to these kinds of problems. I just don't know if it'll make it more determinate or less determinate if they were to go that way, ultimately.
It occurs to me that another argument that will come along with respect to bars and restaurants is that the 21st Amendment gives states extra power to regulate people's conduct in places where there's licensure of alcohol, just as the First Amendment applies differently in bars I think the Second Amendment could be understood to be narrowed after the 21st Amendment.
Interesting. Anybody else on this case? If not, we'll move on. Paul, you have Dobbs versus Jackson Women's Health Organization and related cases.
In related cases. So Dobbs figures to be a big case for the term, and because it seems very likely, and I'm going to be more aggressive than Ramon about predicting that the Mississippi abortion law is going to be upheld. Seems to me the main issue in the case is how broadly will the court rule in modifying its existing regime of constitutional protection for abortion rights. As you all know, the Mississippi law bans abortion after the 15th week of a pregnancy, and that's clearly unconstitutional under the Casey Roe regime, which says that women have to have an access to abortion until the point of viability in their pregnancies, which comes obviously some weeks after the 15th week. Obviously the other aspect of that existing regime is you can have some regulation of abortion prior to viability, but that's where the undue burden test comes in. It can't be imposed too much of an undue burden, or it's taking away the right to choose for women pre-viability. Mississippi was perfectly aware of this when they passed this law. The point of the law is to give the court an opportunity to cut back on constitutional protections for abortion rights. The procedural history of the case is an important part of trying to figure out what's going to happen here. The lower courts have followed the law. This circuit held it unconstitutional. And the state of Mississippi then files a cert petition, which has this bizarre sort of treatment at the Supreme Court level that goes for some months without even being brought to conference. And then it's finally brought to conference in January, and it's relisted. I think the number is 12 times before they finally grant the case. So there's clearly something going on in the court's mind about whether they wanted to plunge into this issue or not. It may have just been about trying to get it pushed back to this term rather than last term. The other piece of it is that the petition was framed very carefully as lots of emphasis on how this is not a facial attack on Roe v. Wade. We don't need to take that down. Lots of discussion about a need for clarification among the court's various cases in this area, supposed tensions between Whole Women's Health and June Medical, between Gonzalez and Casey. The suggestion was that you can uphold this law kind of within the existing regime, obviously with a major modification, but come to the conclusion that allowing abortion through the first 15 weeks of the pregnancy is a way to avoid imposing an undue burden, and that banning it thereafter is not an undue burden because that's a fair amount of time. And in the background here is the fact that the one clinic in Mississippi, the one that challenged the law here, as a matter of its own policy, does not do abortions after the 16th week of pregnancies. So that was the petition. And then we get the brief of the petitioners on the merits, which feels like it was written by an entirely different set of lawyers and takes an entirely different tack. Basically comes in and very aggressively says the Constitution is not correctly interpreted to provide any protection at all from state regulation of abortion. At most, that you should apply a rational basis test. The entire regime of protection that's been erected since 1973 should be taken down, and you should uphold the Mississippi law on that basis. And so, one of the things that is really interesting to anticipate is, will the court be kind of ticked off at the bait and switch aspects of the way this case was litigated by the state of Mississippi? They don't usually like people coming in and saying in their petition that this is a fairly narrow case that can be decided without having to overrule everything. Maybe you can modify things, et cetera. And then a very different, much more aggressive set of asks in the merits brief. And so as this case is being briefed and as they're getting ready to argue it in beginning of December, in the midst of it all, Texas decides to get involved. And so we have this Texas case involving the Texas law, which is very different and much more aggressive, but for a number of reasons, one of which is it bans abortion after 6 weeks. Second of it is that it's designed to prevent easy access to federal court to enjoin the operation of the law, because the state does not enforce the law. Only private civil lawsuits are used to enforce the law, not against anybody who facilitates anyone to get an abortion in Texas after the 6th week of the pregnancy. The 6-week challenge is much more aggressive in the sense that most abortions happen after that point. Many people, women don't even know they're pregnant at the 6th week. And so this created all sorts of complexity as the plaintiffs rushed into court in Texas to try to enjoin this law. They ran into arguments that were about the way the enforcement method was designed that create issues of 11th Amendment immunity. Who do you sue? And under the 11th Amendment, you can't just sue a state whenever you want to in federal court. We have sovereign immunity in the 11th Amendment for states in federal court. The ex parte Young exception to that, which is what makes it possible for the federal courts to enforce the Constitution against the states, has always been viewed as kind of a fiction, because it's based on the idea that state officials, when they're enforcing an unconstitutional law, are not really the state. They're just independent actors acting outside the scope of their authority, and therefore you can sue them. But the only people you can sue under that are the enforcers, the people that actually enforce the law, and you can get an injunction against them from further enforcement of an unconstitutional state statute. Here, there are no state officials to sue, or at least arguably there aren't. The plaintiffs in the first case sued a judge and a court clerk, as well as a private citizen that they anticipated would be filing one of these civil lawsuits against facilitators of illegal abortions. As the case was going to district court, the Fifth Circuit essentially shut it down with an administrative stay that said, don't do anything. And the plaintiffs rushed up to the Supreme Court, and as everyone knows, they got no relief at all from the Supreme Court to revive their case. 5-4, with the Chief Justice joining the liberals in dissent. The court said, this seems very different from a lot of the other cases where we have a clear violation of the Constitution. Maybe the substantive scope of this is inconsistent with the substantive scope of the rights we've established, but we have all sorts of issues of, can you sue these people? Is it okay to sue judicial officials under the ex parte Young exception? The private citizen says he's not going to bring a case. Do you have the right defendants? And therefore, is there anybody to issue an injunction against that is properly been brought into federal court? So that case kind of founders. And the next thing that happens, of course, is that the Department of Justice brings United States against the state of Texas, claiming a number of things. One is that they have various federal programs in which they are involved with, as the federal government, performing abortions that are after the 6th week. They're constitutionally protected under Roe and Casey, and this is interfering with federal operations, and therefore we have standing to challenge it against the state of Texas. But underlying the case and the basis, it seems, for the Justice Department's request for a facial invalidation of the statute is the much broader proposition that the United States has an inherent equitable authority to go into federal court and sue any state in its own name as a state for violating the constitutional rights of any American citizen. There is language in the complaint that makes those arguments. And the citations are to the In re Debs case from 1895 and from a case called United States against City of Jackson from the middle of the Civil Rights era in 1963. It is a very broad claim of power that seems to be going beyond much of that they can find to support it. And so it'll be interesting to see how the federal courts receive this federal complaint. The federal judge who got it reacted by setting it the emergency application for a TRO or PI, preliminary injunction. It was filed by the government for a hearing a couple of weeks later, which is a pretty long period of time for this kind of situation where there is really good arguments for irreparable harm to people from not being able to access abortion services that they have a constitutional right to access under current law. So that judge doesn't appear to be real certain what to do with this situation. When that hearing does happen, whatever that federal judge does, it'll presumably go straight up to the Fifth Circuit and up to the Supreme Court again, with another episode of a shadow docket ruling on a really important issue. Again, dealing with issues that as complicated perhaps as the ones that were before the court the last time this emergency application came up with the private plaintiffs. So it'll be very interesting to watch what the court ends up doing in that case. We have as well now an actual enforcement action by two private plaintiffs against the doctor in San Antonio who announced that he had in fact performed an abortion after the 6th week. And so those cases could also be a vehicle in which the constitutional defense could be raised, and those could rush up to the higher courts as well. But that's different. Those are state court cases, so that raises other aspects of procedural complexity. But it's going to be an abortion term for the court, and we don't know what they're going to do with this Texas law, and as it keeps coming back to them, as I think it will. Ultimately, when the Mississippi case is briefed and argued, they have a very fundamental choice between, obviously they could do three things. They could keep existing law and hold it unconstitutional. It doesn't seem like there's 5 votes to do that. They could narrowly rule that it's not an undue burden and they don't need to go any further. 15 weeks is okay, even under sort of the notion that you still have to give people the opportunity to access abortion services. Or they could go as far as the state asks in its merits brief. And my guess is the conservatives will be split on that, and we'll end up with a kind of fractured, maybe 3-3-3 decision. But I'd be really interested to hear what my fellow panelists have to say about that.
Others? Paul has kind of laid out the possibilities.
So
You don't have to specifically address those, but if you would like to, that's fine. Other comments also.
So Irv, I've got thoughts on Mississippi and Texas, but I'll start with Mississippi because that's where Paul finished. I mean, one of the interesting things that and I'd be curious for Paul's views on this. He's probably closer to the strategy than I am. I had assumed that when Mississippi kind of changed its wholesale strategy and the merits on the court, that the respondents and all of their amici would come back and shout for a dig, saying in essence, you told the court they weren't going to decide this question. It isn't what the case was about. It isn't what you've been pressing all along. This isn't like the Friedrichs line of cases where you were just teeing it up to go after a boot. This was sold to the court as a way to provide some clarity on the meaning of the Casey regime, not as an attack on that regime itself. And the respondents and the government, the U.S. filed its brief yesterday, they sort of hint at that by saying things like, if you want to consider their late breaking arguments, but they don't make the full-throated request for the dig. And I'm not entirely sure why. In terms of the argument, I think the two things that I'm sort of curious to see, as Paul says, the fact that the court took so long to grant the case suggests that the conservatives were trying to determine whether they had the votes, which does suggest that something like what Paul outlined as option number 2 is where they were gravitating toward. Could you say it's not an undue burden because enough women in the state are able to get an abortion in advance of the 15 weeks? It doesn't suggest that they were grabbing onto the case to attack Roe and Casey. It wasn't even presented in that way. So, what kind of skepticism does Mississippi face in the court, or frustration over its change in briefing strategy? And then, on the other side, the United States filed its brief yesterday, the brief is fairly remarkable. It doesn't just argue that the court shouldn't overturn Roe and Casey as a matter of stare decisis. It argues that Roe and Casey are correctly decided under the Constitution. The government's obviously gone back and forth on this between Whole Women's Health and the Texas case, and then the Louisiana case on admitting privileges laws where the administration flipped, and now to this, where they've gone to the ultimate constitutional question and argued straight on the merits, not even just under stare decisis. And so I'll be curious to see if the court pushes back both on what the federal interest is here and the fact that the government has gone back and forth in these abortion cases, just depending on which administration it is.
Other thoughts?
It seems to me that they probably decided, the respondents, that they had essentially zero chance of an actual dig, and so they didn't want to waste a lot of energy arguing for that after the way the court took so long to grant this case, and the court will know it can always rule narrowly regardless of what the merits brief says. It's not bound in any way to go as far as Mississippi is now asking it to do. So, well, I think you're right, Jeff. They hinted at it. They don't really go further, but they presumably are hoping that the court will basically hold Mississippi to its original narrower scope.
So I just
That's
want to
right,
point
Paul,
out.
but I guess I'm just not so sure that there's zero chance of getting a dig if they pushed for one. I mean, it's probably right, but it doesn't seem to me so clearly right that it wouldn't have been worth the try.
So I think
that's me.
I think it was, it's definitely an off-ramp if that's what a majority of the justices want. They can definitely dig this case and they know it. And I'm not sure doing briefing space with a hard pitch increases the chances of that happening. And there is some risk that you're starting to sound defensive. So that may be what influenced it. There is.
Irv, they are defensive.
Yeah.
So, I mean,
yes, no,
by
defensive, I mean, they don't have confidence in the rest of their arguments. Right. Yeah. So the other thing is there is one amicus brief, and I'm not remembering the name of it right now because there are so many, but there is one amicus brief that is fully devoted to a dig. Like Jeff, I think it's a possibility if they can't get agreement on either one of the other two things, options that Paul put on the table. And so.
Or here's the only reason I'm not quite as bearish on it as maybe the respondents are. If Mississippi had approached this case as we're going to dedicate a chunk of the brief to overrule Roe and Casey, but then we're really going to flesh out the arguments on the merits that we told you the case was going to be about, and we're going to explain exactly why you're going to uphold this under the Roe and Casey regime. But they don't spend nearly as much time on that in their briefs as you would have expected. So I don't actually know that they've kind of given the court the full airing on that issue that it expected. And it seems to me there was some room to try to create discomfort among the conservatives, pair that with frustration over the position that Mississippi has put them in by injecting an issue into the case that the court was specifically told wasn't going to be there. And I think you're probably right. They can always take the off ramp if they want, but it seems to me that it's maybe a little less likely if people aren't hammering them about it.
Anyone else?
So I'm really interested to see what the Supreme Court does in the Mississippi case, but I guess I'm more interested to get people's views on whether the Texas case is going to overtake all of this. Like, sure, the Supreme Court has already declined to get involved once, but you imagine the public pressure continuing to grow. And just in terms of the effects, I mean, this is essentially there being almost no ability to obtain an abortion in Texas right now. I mean, that is incredibly significant. And I guess I'm interested to hear what the other panelists think about whether the Supreme Court's just going to have to take that up. And just timing wise, we're talking about an oral argument in the Mississippi case in December, decision well after that. It just seems to me that there's a significant chance that Texas will overtake all of this.
I think that's right, but I still, what I haven't heard, a lot of frustration over the courts not stepping in earlier. But what I still don't know, or at least what I haven't heard an explanation for, is how the court is going to grant relief that's really going to be effective to the defendants, given the posture of the current suits. If it ends up back in a district court and the district court certifies a class, that's right. That's a different kettle of fish. But at least given the current postures, I don't even know. It seems to me either the court had to issue an order that purported to bind a bunch of people who actually weren't parties to the proceeding, notwithstanding Article 3 and due process, or it had to just enter an order in which it essentially told non-parties that they should stand down. And that's sort of, again, it's kind of either advisory or unprecedented. And so, yes, if Judge Pittman or one of the other judges enters a PI and it works its way up through the Fifth Circuit, it'll obviously end up on the court's emergency docket, but it's not entirely clear what relief the court can grant that is going to put an end to the litigation risk down in Texas. Maybe Paul has a better sense of that, but it's just not.
Why wouldn't it be a stay? I mean, that's what they asked for, was a stay, right? Don't allow the law to go into effect. There would be additional time to consider the merits.
But Nicole, what does that look like? I mean, when the court enters a stay, I mean, it enters it with respect to particular parties in the proceedings. I mean, how would the court just enter an order that tells everyone down in Texas, not parties to the proceeding and not part of a certified class, not to do anything, not to sue under the state law?
Does the Justice Department suit, if it were viable, an injunction against the state work or not?
I mean, I think probably, I think the difficulty for the US suit is set aside the standing problem, right? Once you get past federal contractors and federal employees, it's not clear how the United States has standing to seek the broad relief that it wants against all applications of law, including with respect to Texas residents. What's the injury to the United States there? That's in essence sort of Ren's patriae suit for the federal government. But even if you get past the standing problem, as Paul said, I mean, this is a breathtaking assertion that there is just a freestanding cause of action in equity to sue a state in order to vindicate the private rights of its citizens. And it's not clear to me where that stops. I mean, in Roman's case, why not sue? Why isn't in a Republican administration, why isn't DOJ suing blue states over gun laws and so on in all of our cases, religious funding for schools and all the rest? I mean, and so it also just, as far as I know, the United States has never asserted that before, even in the Georgia Voting Rights Act case, right? They didn't walk in and just say, we have a freestanding cause of action to enforce the 15th Amendment. They tried very hard to wedge their theory into the Voting Rights Act. And if this is right, and one of the reasons everybody suspect it is not going to work is because I think it would really politicize the department. I mean, as opposed to just being an amicus or filing statements of interest, as Paul said, the pressure to be on the left side of the V against either blue states or red states, depending on the administration, on a whole host of laws, would be irresistible if this works. So I think, it's a fair question, Irvin. Maybe they will get a court to give them that relief, but if they do, they're going to end up in the Supreme Court. And I'm pretty skeptical that 5 votes on the Supreme Court are going to say that they got standing in a cause of action to do this. And so I'm just not sure that that's the vehicle that folks want in the Supreme Court. It seems to me you could get a ruling that would be bad well beyond this context.
Isn't there another vehicle though now? I mean, it seems like I agree with all the discussion about the complexities, all of Jeff's points and Paul, your points as well about both of these, the US suit and then the suit that got up to the, on the shadow docket. But isn't, you have an actual case now with an actual defendant and an actual plaintiff, like, isn't that the easy answer that case then becomes the vehicle and you don't have to deal with these procedural complexities? You can just get to Nicole's point, which is, there seems to be a law that has a real problem under existing abortion law and Roe and Casey, and can't we just get to the merits in that question and then that can go up as quickly as it needs to?
And how quickly will it go up? I mean, this is a suit for damages against one doctor. What if the Texas state judge just sits on it, or they have a period of discovery or whatever they have? I mean, it doesn't rush up in quite the same way as an injunctive lawsuit in federal court rushes up, right?
It's potential. It depends how the Texas courts want to handle it. It seems to me, if they're deeply concerned about the way Texas has sought to chill exercise of rights without judicial review, if they're concerned enough, then it seems to me it'll be sped up. You only need to get to the Texas Supreme Court which would then be stare decisis for all Texas state courts, I think. And so it would take care of Jeff's problem that you only have one plaintiff. Nobody else, at least in Texas, you would think you wouldn't, if you have a decision from the Texas Supreme Court, that would be good enough for you to, as a matter of stare decisis, feel comfortable enough to go forward. But I don't know. The whole idea here is to chill people because the Supreme Court may ultimately decide 6 weeks is fine. And so.
But can't the guy who's been sued bring his own suit now? His own suit is for declaratory and injunctive relief. I mean, he has a plaintiff who's already gone after him, so it's not really speculative. He says, I want to continue to perform these procedures. I just think like,
is that a Younger versus Harris problem in federal court?
I don't know.
Seems like it is to me, but anyway.
Maybe. I mean, there are plenty of examples like, Bowers versus Hardwick. The guy was arrested under the statute. They didn't prosecute him, but that gave him standing to bring a 1983 action against the statute.
Ah, okay. Well, maybe we're getting into more procedural complexity on top of procedural complexity. And so it's time to move on. Nicole.
I think there's a couple of questions. Are they going to get saved for the end? Is that how this works?
Yeah, we're going to the end on the.
Okay.
Yeah. So Nicole has United States versus Tsarnaev.
Yes, that's right. So here's another case that's going to be heard during the October sitting. This is the Tsarnaev case regarding the capital sentence of one of the Boston Marathon bombers. And so there are two questions that are going to the court, one about voir dire and pretrial publicity, asking a question to prospective jurors about what pretrial publicity they had been exposed to, and then a second question about specific mitigating evidence at the capital sentencing stage. And so just to set the table right away, there's no question before the Supreme Court about guilt. Guilt of the individual was conceded at the capital trial. This is just questions about capital sentencing. So, oh, my dog wants to participate. 1 second, please. I did warn you, Herb, that she is very vocal, but she'll take a little nap now. Anyway, so going back to the facts of this case, because that's really what this is all about, a pretty fact-specific case. As everyone I'm sure remembers, in April 23, at the end of the Boston Marathon, just before 3 p.m. in the afternoon, 2 bombs exploded at the finish line about 10 seconds apart. And 3 people were killed, a lot of people were injured. There was general mayhem and a search for the individuals involved all around Boston. That lasted several days. The FBI released video and asked people to help with the search. There was just extensive publicity as to people who'd been injured, looking for the people who caused it, different theories, etc. A very scary time. And so it turns out that there were 2 brothers who were involved that basically were on the run, and after the video was released, shot an officer, stole the car, and that car was tracked to a residential neighborhood. And at that point, the older brother, Tamerlan, shot at police officers and then was run over and died. And you'll probably remember that the younger brother, Dzhokhar, hid behind someone's house in a boat. Probably everyone remembers that, and eventually was discovered and then arrested and questioned by federal officials. And so his brother is dead, and he's the one who gets tried, a federal trial with 30 offenses against him, and the government sought the death penalty. And this is a case in which he conceded that he was guilty, so that that he was found guilty, and then there was an extensive penalty phase as to whether a capital sentence would be appropriate. And there were several questions that arose during the capital phase, but one of them was what kind of questioning was appropriate of prospective jurors. And in particular, the defense wanted the jurors to be asked, what do you know about this case before coming to serve as a juror? What kind of things did you hear in the media? And actually, the government originally supported asking that question, but eventually determined that other questions they thought would kind of get at the issue. The defense continued to say that question was important, that it was very relevant to the jurors' ability to be impartial. Another issue that arose at the penalty phase was about mitigating evidence. And so, as folks probably know, in capital cases at the penalty phase, the Federal Death Penalty Act provides very broad rules for introduction of mitigating evidence. The Supreme Court also, under the Eighth Amendment, has precedents that very broadly permit any relevant mitigating evidence. And in fact, the federal law, the Federal Death Penalty Act, says that the evidence doesn't have to be the kind that's even normally admissible at a criminal trial. It can come in as mitigating evidence. And so in this case, there was a particular type of evidence that the defense wanted to get in, and it had to do with an offense that the older brother, Tamerlan, had committed in 2011. Actually, a brutal murder that he committed on the 10th anniversary of the September 11th attacks. And Tamerlan, as I said, was dead, so he couldn't say anything at this penalty phase. But an accomplice had previously confessed, talked about Tamerlan being the instigator, talked about what happened during that 2011 offense, gave details about it. Well, the accomplice also was unavailable. And so the government said that this evidence was not very probative, that it was outweighed by its potential prejudicial effect, and that it was unreliable. And so it shouldn't come in. And so, the defense said, no, this evidence is really important. It matters because one of our main theories is that the younger brother acted under the influence of the older brother. The older brother was more dangerous. The older brother was trying to get him involved in jihad, and that this evidence was very important. And so this went to the First Circuit. There were a lot of issues raised on the appeal of the capital sentence. I should say that the jury issued or imposed a capital sentence, I think, on 6 of the 17 possible capital counts. And so that went up to review in the First Circuit. First Circuit issued a very lengthy opinion in the Federal Reporter. It takes up 100 pages. I don't know how many pages it takes up in the petition appendix, but let's just say a lot. It addressed many issues in great detail. It focused in particular on these 2 potential bases for reversing the conviction. First, the failure to ask the jurors specifically about pretrial publicity. And then second, the failure to allow mitigating evidence in at the penalty phase about the older brothers committing murder in 2011. And the First Circuit found that each of those was a basis for reversal of the conviction. Those were both independent bases for reversal of the conviction. And the government sought cert. So as the case went to the Supreme Court, the government presented 2 cases. The first is, did the Court of Appeals err in saying that the district court should have asked each juror about pretrial publicity? And second, did the Court of Appeals err in saying that the district court should have allowed introduction of this mitigating evidence about the older brother? So at this point, you might be thinking, this does not sound like these typical questions presented to me. Perhaps this does not sound like a typical cert candidate, because these are questions that are very, very focused on the evidence at this particular trial and the law that applied to this particular trial. And to a significant extent in the government cert petition, it admitted that this is primarily an error correction case with pretty case-specific questions and would likely result in pretty case-specific rulings. But the government's position was that the gravity of the offense, as well as the burden to actually have a retrial on the capital sentence, which the government said it would do, it would retry the individual for the capital sentence, that burden was enough to justify Supreme Court review. So the timing of this was pretty interesting. The cert petition was filed in October of 2020. I think everyone recalls that end of 2020 was a pretty busy time. First, it was a busy time for the federal government. They had resumed federal executions in June, and there were many in the December and January timeframe. It was also a busy time politically because there was a presidential election, a new administration coming in. Interestingly, this case, I think, was designed to get it on the court's calendar for last year. All the papers were in December, and the case was first distributed to the justices to be considered in December. But they didn't make any decisions then about whether to grant review. They waited perhaps to see what a new administration might do. I think there was some question there because the president had voiced public opposition, publicly had voiced opposition to capital punishment. And so perhaps there's a question about what the new administration would do. But it got to the point in March where the administration had not taken any action to change position. I think this case was relisted 7 times, and the court granted cert and teed this up for October. So the court has before it 2 questions, both pretty specific to the facts of this case, both pretty interesting. The first is one about whether the district court should have asked each juror about the pretrial publicity to which he or she had been exposed. The Court of Appeals view on this whole thing was, look, the pretrial publicity here, I think the court's words was unrivaled in American history, just a huge amount of pretrial publicity when the bombings occurred, when the FBI was looking for the suspects. There was a point at which when the brothers had been spotted in a neighborhood where folks in the Boston area were told to shelter in place, a lot of public sentiment, public concern, public publicity. There was also some false reporting, the Court of Appeals noted, that happened at the time, and some reporting that could be very prejudicial. For example, the fact that there had actually been a confession that the government had obtained in a hospital that was not admissible, not admitted at the trial, but was something that was reported in the public. And the Court of Appeals said, in these circumstances, we have adopted a supervisory rule that when there's a significant possibility that the jurors were exposed to prejudicial material, when the district court thinks there was, and on the request of counsel, a question should be asked about the kind and degree of exposure to prejudicial pretrial publicity. And so this is significant because the Court of Appeals holding was not a Sixth Amendment holding, like the defendant here did not have a fair trial because his question wasn't answered. It was a supervisory rule holding that, the court thought that this was a rule that made sense. It also cited to an ABA standard that suggested that a similar question was appropriate. So when the government filed its cert petition and filed its brief in the Supreme Court, I think it made several arguments about why this particular question didn't have to be asked. The first point is the government said, look, there was a 21-day process here of voir dire and jury selection. So a very large amount of time spent asking jurors about prospective biases, including specific questions about what sources of news they viewed, generally how much news they had seen about the case, and whether they had formed an opinion about the defendant's guilt or innocence. And so that was a robust process, I think, is the government's kind of first point. The government also noted, I think, that the district court had declined to change venue, had determined after the jury selection as part of that process that the venue remained appropriate despite potential pretrial publicity. I think the government also makes some interesting arguments about deference to the district court. They say, the district court was the one who had this whole trial and had to go through this jury selection, this amazingly long, complicated process. District court was in the best position in the government's view to judge what kind of questions were appropriate here. And the rule that the First Circuit articulated in the government's view is really an inflexible rule that you always have to ask this question or you get a reversal. And then, the other argument that I gleaned from the government's brief is just a practical one, that in the government's view, the questions about that were asked about potential biases worked, because in this case, the jurors had extensive deliberations, they gave 2 notes to the court and asked questions, and they eventually issued a very nuanced verdict where they only imposed a capital sentence on some of the capital counts and not others. I think on the other hand, the defense here says, well, this is a pretty basic question. What do you remember hearing about the case? This is a case where pretrial publicity was really at its height. It's hard to find a case where there was more pretrial publicity about this. You're not going to know if it influenced a juror unless you ask these particular questions, and that's the role of the district court here. And the defense, I think, also supports or pointed to the broad authority of the courts of appeals in adopting supervisory rules. So to some extent, the government's saying defer to the broad authority of the district court. They're the one who has to do this capital sentencing proceeding. But the defense says, not so fast. There's also, you've recognized broad authority of the courts of appeals to put together supervisory rules for trials, and why wouldn't you continue to give them that broad discretion? Tsarnaev also points to some interesting cases, including by the Supreme Court, of racial prejudice, where there were instances in which prospective jurors had to be asked about their risk of racial bias and how it might affect a case here. And then, there's also an interesting point, I think, that Tsarnaev made about how, unlike prior cases the Supreme Court considered, there are so many sources of potential publicity and news now, including with social media, that perhaps the district court could not easily know all potential sources of pretrial publicity, which is why in this case, one would have to ask to know. So to me, this seems like a fairly difficult argument for Tsarnaev in light of the fact that the voir dire and the jury selection process had been such a long process. On the other hand, there are these ABA standards, and the ABA filed an either party brief in this case that talks about asking this kind of question and how important it is in cases with extensive pretrial publicity. And it's hard to argue with the fact that this was a case with just an immense amount of pretrial publicity. So I'll talk briefly about the second issue, and then of course, I'm sure my fellow panelists will want to weigh in. So the second issue has to do with the district court's failure to allow mitigating evidence about the brother's past crimes. This is a very interesting issue because it arises under both the Eighth Amendment and the Federal Death Penalty Act. The Eighth Amendment, as a general matter, allows presentation of mitigating evidence about the defendant and about the offense. And the Federal Death Penalty Act takes a very broad, expansive view as to admissibility, with the theory of that this evidence should be allowed in, and before the capital sentence should be imposed, the defense should have really the chance to make any reasonable mitigating arguments. The Court of Appeals here said this evidence that the defense wanted to put in is relevant and important because one of the main issues with respect to how to sentence the individual, in this case, the younger brother, there was a real question about relative culpability. That his argument was that he was under the influence of the older brother, that the older brother was incredibly violent, that the other brother had decided to engage in jihad and was trying to recruit him since 2011. Remember, these offenses occurred in 2013. And that was really a story that the defense wanted to tell, that Tamerlan, the older brother, was the instigator who was trying to influence his younger brother to join. And the government said a couple of things in response. So the Court of Appeals said that this evidence was important and should have been admitted, and that it was reversible error, that it was not harmless to allow this evidence, that it was not a harmless error. The government says a few things about this. The first is it points to the fact as a starting point that whether to admit evidence is entrusted to the broad discretion of the district court. As a starting point, again, this is relying on the perspective of the district court, who is very near to this case. It also says, the focus of mitigating evidence is supposed to be on the defendant and what the defendant did. And it takes some logical steps to get from what the brother did to what the defendant did here. And really that this, in the government's view, was going to be a distraction because there would have to be a mini trial about what the older brother did. And just to spin this out a little bit, the idea is the older brother is not available. And the individual who provided the evidence about the older brother engaging in this crime, committing this crime in 2011, also was not available. And so, you have to have this mini trial about what happened in the government's view. You have to have this mini trial about what happened in 2011, what were the circumstances of the crime, et cetera, et cetera. And then the government also argues that any error here was harmless beyond a reasonable doubt. I think that, this is a case in which the defense has a stronger argument on this issue as opposed to on the first issue. The defense says this was fundamental to our theory of the case. Our theory was, one of our mitigating theories was that this younger brother was under the influence of the older brother. The government argued that the younger brother was really the driving force or a driving force behind the Boston Marathon bombings. And the defense response was that, no, it's the brother who was a violent and radicalizing influence. And other evidence came in about things that the older brother had done, including him like once yelling at a butcher. And the defense response to that is, well, this is much more probative than that, yelling at a butcher versus a brutal murder in 2011 in the name of jihad. How could that not come in? There were some interesting questions here about whether the evidence was reliable. The defense pointed out that the government actually relied on this evidence about the 2011 offense to justify a search warrant of the older brother's car after the older brother had been killed and the younger brother had been captured. So, the defense says, well, if it was reliable enough for a search warrant, it sure seems like it's reliable enough to come in at the mitigating stage. And we don't need to even have a mini trial. We can just put the search warrant into evidence. So when you think about how the Supreme Court might assess this, I think, the Supreme Court, it's a little awkward for the government, having relied on the search warrant, to say this evidence would not be relevant or would be too prejudicial at the mitigating evidence stage. And the evidence does seem quite relevant. On the other hand, the government is urging the court to undertake a harmless error analysis. The Supreme Court normally doesn't do that. Harmless error analysis requires so much sorting through the evidence in the case. They don't normally see that as their role. But, in this case, I think the court may, because it will be mindful of the burden of retrying the case, which was the justification that the government used for trying to get cert granted, and one of the justifications for getting cert granted in the first place. So I think there are a lot of interesting and complicated issues here, many specific to the evidence, but it's certainly a case in which the court thought that sorting through it would be worth the court's time. So I'm interested to hear what my fellow panelists think of this case.
Anybody on this one?
Yeah, so Irv, as Nicole knows, this is a petition I authorized and filed, so I'm only going to talk about what's in the public record. I'm not talking about anything internal to DOJ. I do think maybe the most interesting thing about it was whether the government was going to pull the petition, which the court clearly gave them time to do. I don't know why the department didn't, but I wonder if it's one thing to say that you're opposed to capital punishment. It's another for the United States Attorney's Office to tell the good people of Boston that you're no longer going to pursue the death penalty against the Boston Marathon bomber, or one of the two. And so they didn't. And Nicole's right. I mean, I think on the jury question, I think the government's arguments are pretty strong. Tsarnaev's counsel is very good. Ginger Anders has done a nice job and flipped it and led with the evidentiary question and not the voir dire question. And I do think Nicole's right that that's a harder question for the government. And I'll be really curious to see what the court does with it.
Anyone else on this one? Yeah, so is there any, I mean, usually when a court takes a case like this, we can predict the outcome. You usually take cases like this to reverse. Every once in a while, once the case is fully briefed and they actually see what's in front of them, what seemed like an easy reversal doesn't seem so easy anymore. I have a sense that what once seemed really easy may not seem quite as easy anymore on this second issue. Just because, I mean, this is the way I think about it. If you accept the Eighth Amendment principle that somebody pretty much has a right to bring in almost anything that's mitigating, whether it satisfies rules of evidence, normal rules of evidence or not, this does seem like if you don't allow the defendant to bring in this evidence, you've basically deprived him of the only defense against the death penalty he was offering. And I think that will give some pause. Now, enough pause, probably not, but some pause. So with that, I turn to Jeff, and he has Carson versus Macon.
Thanks, Irv. I'm going to be really quick on this one because I think the case is not as complicated as some of the others, and I suspect we're all unanimous on how it's likely to come out. So it's really kind of the third of a trilogy in a pair of cases that you all know, Trinity Lutheran and then Espinoza a couple of terms ago. The court has held that religious institutions, churches and schools can't be disqualified from otherwise generally available public aid on the basis of their religious character, or what the court has referred to as their religious status, which is to say just the fact that they are religious or that they are affiliated with a religious institution. In arriving at that rule, the court has drawn a distinction between status and use, driven by a case called Locke v. Davie. Washington State had a scholarship program for college students, and it paid for anything except devotional theology. If you wanted a degree, basically aiming toward becoming a minister or a member of the clergy, Washington wouldn't pay for that. And the court upheld it 7-2 over dissents by Justices Scalia and Thomas. So because that data point is out there, the court has always distinguished and said that's religious use. The use of the funds for a religious purpose, inculcation in religion for purposes of becoming a minister, a member of the clergy. We're not weighing in on that, they said in Trinity Lutheran and Espinoza. All we're saying is that with respect to religious status, there is this non-discrimination principle that if you make the aid generally available, you can't exclude the religious institutions simply by virtue of their, what the court has said is religious status. So along comes this case, and it's out of Maine. Maine is quite rural. I did not realize exactly how rural until I looked at this case. There are some 250 odd what they call local administrative units, which I think are just like towns in Maine. And they're required under Maine law to have schools for everybody, all minors. The problem is that roughly 140 of them don't find it worth their while to have schools, presumably because there aren't enough kids there to make running a school worth it. So the state has a statute that says, well, If you're a town and you're not going to have a school, you can either contract with another public school or private school to take all your students, or you can just give out tuition assistance. Think of it like a voucher, payment assistance. You can just give the money to the parents, and the parents can choose which school their children attend, subject to one limitation, which is the whole basis of this case. It has to be a non-sectarian school, the main law says. So at first blush, that sure looks like a status case, and the United States so argued as an amicus to the First Circuit, because in determining whether a school is sectarian or non-sectarian, the government said, that sure seems to turn on whether it is religiously affiliated or has a religious character. It doesn't seem to have anything necessarily to do with the instruction that actually goes on at the ground at the school. Maine, presumably because it saw the laws coming in Espinoza, argued that its law is not status-based, it's use-based. And they said, we don't determine by just looking at something like status or religious affiliation. We look at your school and the kind of curriculum it offers. And if we find that the curriculum is intertwined with religion and that you are teaching even secular subjects through the lens of faith, then we will deem you sectarian for purposes of the statute, but we understand that as about use, not as about status. And the First Circuit accepted that characterization of the statute over the government's arguments. And it then went on to say that the law was perfectly permissible, notwithstanding Trinity Lutheran and Espinoza, because in the First Circuit's view, what Maine is trying to do is offer you the equivalent of what you would get in a secular public school if your town had such a school, and the religious education is not a substitute for that in the state's eyes. It is not equivalent to a secular public education because, again, it's being taught through a lens of faith. So the First Circuit said the two things are just not equivalent. As it comes up to the court, then it's a case about use. Again, the sort of oddity of it is that I think in the way the court has been using those terms, many of the justices are going to think this seems an awful lot like a status case and not really like a use case, but that's the way it's been framed and the court took it. Having done that, I think this is I think there's an easy use case and a hard use case. And I think this is the kind of easy use case in which the petitioners are likely to prevail, really for probably two, maybe three reasons. The first is, if this is use, then the court really, I think, has to uphold the challenge to the main law, or it threatens to gut the status cases. Because if the rule in Espinoza, if that non-discrimination principle can be avoided by the states saying, well, we looked at your schools and we didn't just rely on the fact that you're affiliated with the church, we relied on the fact that you teach things through the lens of faith, and hence everything that you do qualifies as a religious use. A, it starts to collapse the distinction between status and use, and B, it makes the status line suddenly no longer very important, because it will turn out that virtually all religious schools will be religious in some sense apart from just a naked affiliation with a church. Maybe they will attend chapel, maybe they will have a religion class, maybe there will be religion icons on the wall, maybe there will be some members of the faith who teach some of the classes and who teach them from a religious values perspective. And if that alone is enough to get you into what I'll call the use box, then you can reframe all of the status cases as about use. And you can probably even reframe the Trinity Lutherans of the world simply by finding that the Bible school classes play on the playground. And I don't think the court is going to accept that those cases are so unimportant. The case also comes up on about the worst possible facts for folks who want to defend laws like Maine's, because Maine is here saying we have this strong interest in giving you the secular public education, and this is not the equivalent of that. But of course, the interest wasn't strong enough to actually, for the towns to have schools, or even to contract with other towns that do have public schools. They've just decided, in essence, to direct money to the parents and let the parents make that educational choice. And having done that, I think it's going to be difficult for Maine to make a compelling case in the court that it has the kind of interest that's going to get past this non-discrimination principle. So on the facts here, I don't actually think that I'd be surprised if the court didn't reverse what the First Circuit did. I think the interesting question in the case is, what about the hard use case? What about if a state came along with a law that was more tailored and that actually said, well, we're not going to deny religious schools per se, because we recognize that although they teach through a lens of faith, we can accredit them under the same standards we accredit everybody else, and we can test and we can make sure that they teach social studies and English and math up to our state standards. But we are not paying for the time you spend in chapel or the time you spend in religion class, and we're going to parse it out in that way, and that we're allowed to do under Locke v. Davie. That strikes me as the harder use case, and I think by virtue of the way Maine has litigated this, I think it's sort of, is the court's decision going to cover that case, or are they going to try to reserve that case and set it aside and leave states some flexibility to try to craft systems that look more like Locke v. Davie? We will generally pay, but not for things that are essentially religious instruction or religious endeavors, right? Attending chapel, training ministers, that sort of thing. I think they're probably on stronger historical ground there. They're certainly on stronger precedential ground with Locke. But because Maine has just pitched this in general as a use case, is the court going to talk about the use bucket in a way that separates out this case, which is somewhere between status and use, but I honestly think closer to status, from what I had always thought of as the true use cases, which don't really look like this one. And so that's what I'm sort of interested to see at the argument, is if people focus on this distinction. But curious to hear what others think.
Anybody else on this one?
It does seem like an easy case for them to say, given all of the factors that were described, that they're going to rule against the state. The real interesting question is, how far are they going to go to actually undercut the foundations of Locke versus Davie itself and say, well, as long as as long as you're just treating everybody the same, it doesn't matter what they study, and that may be a direction they'll end up going. But maybe, they don't have to go very far in that direction in this case.
So are there, I seem to recall, and maybe Jeff, you remember and better than I do, that there are some federal statutes that draw lines prohibiting aid for use. Am I wrong about that or not?
I don't remember, Irv. There was probably a time when I knew this, but I don't remember.
Yeah. So I mean,
I
don't think anybody's brought those up. And if you do draw this, what Paul said is the broadest line, or Jeff, you were talking about it too. It may be that you're running into some of what I'm remembering anyway is some federal statutes that seem to have use restrictions of some kind in otherwise neutral programs where they don't disqualify based on status, but they don't allow the funds to be used to sort of, preach the gospel.
Irv, now that you're saying this, I think OLC did have an opinion a few years back looking at one of the HCBU laws that limited funding for certain activities at historically Black colleges and universities. And I can't remember what the memo concluded about status and use, but I think you are right. There are some laws like that out there. That at least comes to mind as one example. So
I think I will, with that, go on to the two cases I have: Ramirez versus Collier and Students for Fair Admission versus President Fellows of Harvard. And I'll try to be brief with both of these. Ramirez is an inmate scheduled for execution who seeks to have his spiritual advisor touch him and audibly pray for him during his execution. Texas allows spiritual advisors to be in the room, but does not permit physical contact or audible prayer. And Ramirez claims this violates his rights under the Religious Land Use and Institutional Naturalized Persons Act, which is known as RLUIPA, which says that the government shall not impose a substantial burden on an inmate's religious exercise unless the government shows that the policy is the least restrictive means of furthering a compelling interest. The Fifth Circuit denied Ramirez's stay of execution by a vote of 2-1. The Supreme Court granted certiorari on 4 issues, one of which is procedural and one of which is remedial, and I'll talk about neither of those, but there are 2 substantive issues. The first is whether Texas is imposing a substantial burden on religious practice, and the second is whether the prohibition and contact on audible prayer are the least restrictive means of furthering a compelling interest. So Ramirez's argument on substantial burden is this: for him, receiving audible prayer and physical contact from his spiritual advisor during execution is a religious exercise that will assist him passing from life to death and will guide his path to the afterlife. Texas has argued that a substantial burden only exists if a person is denied a benefit that no one else receives, or if the state is coercing somebody to violate a religious practice, and it says that neither of those is happening here. Ramirez's argument on compelling interest is that the state has never explained why physical contact or audible prayer would interfere with his execution. Texas responds that deference is owed to its judgment that its policies further the compelling interest in maintaining an orderly, safe, and effective execution. And it also notes that the Bureau of Prisons has the same 2 restrictions, and that Ramirez points to no prison that allows physical contact or audible prayer in the execution chamber. All we have to go on so far is a docket shadow case called Dunn against Smith, in which a majority of the court ordered Alabama to honor Smith's request to have his spiritual advisor in the execution chamber. Justice Kagan spoke for 4 justices, explaining why, in her view, there was both a substantial burden and the absence of a narrow tailor, or the least restrictive means to a compelling interest. But we don't know even who else voted in the majority or why. So we know that Justice Kavanaugh and the Chief Justice dissented on the grounds that this was the least restrictive means of furthering a compelling interest, but that's all we know. So given the murky nature of the decision in Smith, and given the very rushed and unfleshed out nature of the parties' papers so far, it's really difficult to predict what the court will do with this case after full briefing and argument. It does put into conflict, though, 2 values I think all the justices care about: burdening religion and on the one side, and allowing the state to operate its executions in the most safe and effective way possible. Anyone else want to comment on this case? Okay, so that brings us to the last case, and then we'll have time for questions. In Grutter versus Bollinger and Fisher versus the University of Texas, the Supreme Court held that race may be used as a factor in admissions to achieve the educational benefits of diversity. The composition of the court has changed dramatically since then, perhaps inspiring the petition in this case. The challenge here is to Harvard's use of race in its admissions process, and there are basically 3 arguments. First, that the court should overrule Grutter and hold that race cannot be used as a factor in admissions under the Equal Protection Clause. Because Title VI incorporates the equal protection standard and applies to private universities, race can't be used by private universities either. Second, that Harvard is intentionally discriminating against Asian American applicants through its evaluation of personal factors. And third, that Harvard's plan is not narrowly tailored to any compelling interest because it gets too much weight to race and rejects race-neutral alternatives. The district court in the Fifth Circuit upheld Harvard's plan. The court, to the surprise of many, did not act on the petition. Instead, it called for the views of the Solicitor General on whether certiorari should be granted, and that response is likely to come sometime before the end of the year. On one level, this case seems like a surefire grant. We know or suspect that a majority of the justices on the current court are not fans of Grutter. On the other hand, the court may not view this as an ideal case to revisit its precedents. For one thing, it's only been 5 years since Fisher. It may not wish to so swiftly reverse course. For another, the case arises under Title VI and affects private universities. It does not involve state universities subject to the Constitution's Equal Protection Clause. And even though the court has equated the two standards, it may view a case involving a state university as presenting a better vehicle for reconsidering its equal protection precedents. Uncertainty about whether to take the case may explain why the court has called for the views of the Solicitor General. Other explanations, however, seem far more likely. Perhaps the court viewed this term's calendar as already overloaded with controversial cases and wished to push this case on to the next term. Perhaps it wanted to push this case well into the second half of this term. Or perhaps it wished to take into account what was happening in other controversial cases before deciding what to do with this case. If the court does grant cert for either this term or next, what it will do is not clear. The Chief Justice has famously stated the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. The most direct path to that outcome is to say that the educational benefits of diversity are not sufficiently compelling to justify the use of race, eliminating from all colleges and universities any opportunity to use race to further diversity. In this environment, I think it's difficult to see a majority of the court going that far, but I wouldn't rule it out. It does seem far more likely that the court will prefer some other seemingly more narrow and less provocative way to make it exceptionally difficult to justify the use of race in admissions. All this is speculation, however, and it's premature. The first step is to see whether the court takes the case, and we will not know that for a while. Comments on the Harvard case?
Well, it seems to me that the delay explanation is by far the most likely. I mean, it's not like they didn't know what they were going to get back from the Solicitor General's office when they had made the request, which suggests that they are inclined to take it. They just didn't want to take it too soon. But, you know, as you say, it's all speculation.
Yeah, I guess one thing that sort of jumps out is the timing. I mean, I think the normal practice in the Solicitor General's office would be to file the response brief in time so that the case can be considered to be granted this term. I know that the justices can obviously delay even after the CVSG brief is in, but it does seem like they're going to have to do some real gymnastics to kind of kick this case to the next term. I kind of agree with Paul that there are votes to grant, and with you, Irv, there are probably votes to grant this case. But it will seem a little weird, but you know, they've done this kind of thing, this sort of delay tactic on other cases. They're going to have to work to get it into the next term, if not at the end of this term.
Anyone else?
I'll just
That's
say-
become more a norm than an exception these days. They have these cases that sit around for months and months and months that they don't grant, and then they do. So Dobbs is one.
Yeah, I agree with Paul and Ramon. I think delay is the likely explanation. I mean, and I think the government can file its brief at any point because all they need to do is disagree with every word of the brief that the government filed in the Court of Appeals. So they just need to draft the exact opposite, and surely that can't be too hard. And then the court can put it over to next term. I think it's a grant. It's of obvious importance. I think it's hard to argue that Grutter and Fisher have resolved this, as the record in the Harvard case shows. I think the court likely will grant. I think on the merits, Harvard has kind of two problems, and I don't think it faced quite the scrutiny in the lower courts that it will in the Supreme Court that it's going to have to deal with. The one is that the racial composition of its class stays remarkably stable over time. The variance for each racial group within the class is within 1.5% to about 2.5%. So as kind of segments of the pie, they stay remarkably stable from year to year. And part of that, and the problem that I think Harvard's going to face is, everybody acknowledges that Asian Americans are doing less well on the personal score, the personal rating part. And what neither the district court nor Harvard has been able to explain is why that would be independent of race. Surely it's not that Asian American students are any less of the things that rating is supposed to take account of. They're any less likely to be leaders on campus. They have any less integrity. They're any less likable, any of the rest. And so there's a real question of burden. Who bears the burden? Do the challengers have to explain what's accounting for that difference in the personal rating? Or does Harvard, having admitted race into the process under strict scrutiny, then bear the burden of explaining why you're seeing that disparity for Asian Americans? I suspect that the court would be drawn to the latter, both because of its rulings with respect to affirmative action and just because of the way strict scrutiny usually works. It's meant to sort of smoke out use of race. And if Harvard can't offer a good explanation for the disparity independent of race, I think it's going to be tough for the court to overlook that. And if it doesn't, then I unlike you, don't think it's hard to predict where the court will end up on the merits. I think they will say that Harvard's system is infected by race in a way that the Constitution doesn't allow.
So, Jeff, it's interesting. The points you raise all, it seems to me, fall within sort of question 2 presented by the petitioners, not question 1. And so I'm taking from what you're saying that you think the court will be much more attracted to applying its Grutter and Fisher and saying Harvard loses under those cases than it will be in simply overruling Grutter and holding that universities can never use race in admissions. So am I implying too much from what you're saying?
No, I'm not sure. I mean, I think your intro kind of captured it, but both in Dobbs and again in this case, there is an off-ramp for the court that would not be hard to take that falls well short of a broad ruling. And it seems like every couple of years in my adult lifetime, there are predictions that the court is going to deliver these resounding and extremely broad conservative rulings that will imperil its legitimacy. And it rarely comes to pass. It hasn't so far with respect to abortion or race. So I'm not sure why we should naturally assume that the court will do it now. I'm not saying it won't, but I don't at all think it's clear that the court will resolve.
That's really the question, though, Jeff. Is this a different court with 5 justices, arguably to the right of John Roberts on some of these issues?
You might think so, Paul, but how many weeks did they sit on Dobbs? And now they've kind of put off Harvard. Now, granted, maybe for reasons independent of Dobbs, but at least the very few tea leaves we have so far don't suggest that they're rushing to take these cases because they're eager to deliver some very broad ruling.
We shall see.
Anyone else on Harvard? Okay, so I think it's time for whatever press questions there are.
So I was saying we are now going to invite press to let us know that you'd like to ask a question. Please send a Q&A question or raise your hand, and I will allow you to ask your question. I'd like to recognize first Pete Williams from NBC News. You should be able to now unmute yourself, Pete, and ask your question.
Thank you. I have a question for Paul. Paul, if the Supreme Court were to go whole hog on Mississippi's point, overturn Roe and say there really isn't a right to privacy in the Constitution, what would that mean for the line of cases you're familiar with, Lawrence and Obergefell?
Well, I think there are lots of practical reasons why overruling Obergefell and Lawrence is quite unlikely. Those seem like cases that are very hard to unravel. And they have another off-ramp, which is to say, well, maybe there is no substantive due process basis for those cases, but equal protection would have been an alternative basis to say that you cannot regulate, deny equal marriage equality and the like. And so I think there's a lot of ways down the road before they're going to be getting to the point where they're going to overrule Obergefell. Given that, it wouldn't really accomplish very much. You can't unmarry people, and most of the states in the country will continue to marry people. I just don't see that as a very likely thing very soon, although it does put them in a doctrinal box, as you point out.
Thank you.
I see that I believe Adam Liptak has wanted to ask a question. I apologize. This technology for questioning is not the best, but we can unmute you if I am correct to see if you'd like to ask a question. Adam,
I did not raise my hand, but thank you for calling on me anyway. Let me return to, since I have the opportunity. Let me return to the Texas law. So what is the most likely vehicle for it to get definitively adjudicated?
Do I have to answer that? It seems to me that there will eventually be a appeal up through from one of these civil judgments, and that is the nicest, cleanest way for it to get there. And at that point, it's hard to imagine what the jurisdictional problems would be that would prevent it from being decided, but that could take a while.
Thank you.
I'm not going to give you an answer, Adam, but that's the question that is the hardest question, at least one of the hardest questions. I think that is the answer that everyone on both sides of this is talking about.
Right. Well, as you pointed out, though, Nicole, earlier, it has the awkwardness that it could leave an effective ban of abortion in place in Texas for months and months. And if they don't end up going all the way in Mississippi and saying, well, there isn't any right anyway, that's pretty awkward.
And there seems to be a concerted effort on somebody's part to stop people from filing lawsuits. Now, this one person did file a lawsuit. It's not, I mean, the state can have, the statute says that anybody can file a suit. That doesn't mean that there's not some state constitutional limitation on who could file a suit. Maybe I'm not aware of it, but this person seems to be somebody who has no objection to abortions. He just wants to earn a bounty.
There are two of them that sued, I think, and neither of them is actually an anti-abortion activist.
Yeah, so you wonder whether, you wonder if a suit like that can go forward under the state's constitution. I don't know. So I'm not sure. That could be yet another impediment to one of those, that being a really good vehicle, because as I understand, the main anti-abortion groups are, and correct me if I'm wrong, are telling people not to file suit until the Supreme Court decides Mississippi. So I think it's hard to see what the vehicle will be. I do think that the Justice Department will probably produce a Supreme Court shadow docket decision. And I think we've discussed whether it will work or not, with most of us thinking probably not. But
well, they may be able to get some as-applied relief or something like that, but they're not going to get a big injunction against the whole statute, I don't think, for the reasons that Jeff pointed out.
I mean, do we anticipate that that's going to be within the next couple of months? But where it will reach the Supreme Court shadow docket probably within the next couple of months.
Hard to see how it wouldn't.
Yeah.
Well, I read the government's brief yesterday and noted that the government was moving for divided argument in the Mississippi abortion case. I thought it was a very strongly written case, and I wonder how much impact the government's participation in oral argument might have on the right side of the court, as the phrase was used earlier in this program.
Anybody want to take that? This seems like a good one for Jeff, and you can just turn it around and think, how much would the left side of the court have paid attention to a brief that you filed?
I mean, yeah, look, given the fact that the government filed a brief, it was going to ask for argument time. It always does. And particularly in a case of this magnitude, they have to go. How much will it move the needle? I'm skeptical that it will move the needle on what the court does. I think the most interesting impact is just given the arguments in the government's brief, I think it's going to be interesting to see how the government gets questioned, and it may let us have a little bit more insight and argument about where they're going to go and what their thinking is. But I don't, given how long they sat on this case, and they're well familiar with these arguments, I don't think the government's brief or argument is going to change what happens in the case. Just by way of saying, Irv, that a lot of the briefs that we filed also did not change anything the court did in the case. I recognize that.
Anybody else on that, on the government? Do we assume that the court will grant the government's motion for divided argument?
Oh, yes.
I think it's fair to say they'll do that.
I mean, maybe not out of kindness or generosity to the government, but they're going to grant it.
Yeah, so by then, I think the Solicitor General will have been confirmed, I assume. And so the Solicitor General, I assume, will argue. And, that I think it will make for interesting observation for me to see that the exchanges that the new Solicitor General will have with the justices.
The interesting thing, Irv, is that I saw on Twitter while we were doing this that the court has revised its counsel guide and told people that they're going to continue to do seriatim questioning even once they come back.
Really?
And counsel should be
Really?
prepared for that. And I assume that's why they've been giving the government an extra 5 minutes, because it was too benign a fiction that they were ever going to be able to do that in a 10-minute amicus argument. So they've expanded it to now the government gets 15. The interesting thing is it seems like in some of those cases, they haven't expanded the other side's argument time. So the side the government is supporting effectively gets 35 minutes and the other side just gets 30. I have to think that the court's eventually going to do something about that. That doesn't seem fair to me.
Yeah.
Well, that's a shock to me that they're going to continue seriatim questioning.
I think, Irv,
Well, at least the
that,
justice will have the opportunity.
I think it's a hybrid approach that individuals have their normal amount of time, and then there's an opportunity for each justice to ask a question after that. I understand that the court sent out guidelines this morning, and some of the counsel were seeking clarification on that, that it's not entirely the same as last year, but more of an addition on top of the normal free-for-all.
Okay. Do we have other questions, Debbie?
We do. I'd like to recognize, please, Greg Storr of Bloomberg News.
Hi, and thanks to you all. This has been really an interesting panel. Just back on the Texas case, and I don't want to drag us too far down into the weeds, but putting aside the abortion question, is there an obvious way to deal with the structure of the Texas law and this concern that Texas has created a roadmap for, say, a blue state to allow private lawsuits against somebody over, having a gun in their home or something like that? Is there a mechanism where the court can deal with that whole issue of, shouldn't there be somebody we can sue to challenge this obviously unconstitutional law?
So I realize a lot of people have put up the possibility that this could be spread over to blue state laws. I frankly think this strategy only works in situations in which there is a realistic chance that the court is going to overrule its precedents. Because otherwise, the people subject to the law will just ignore it. And when somebody files a suit against them, they'll say it's a frivolous suit and seek attorney's fees from the other side and costs. And I think the only reason this really works as a deterrent to engaging in the conduct in the first place is there's a good faith belief that the court may revise its precedents. And therefore, people are genuinely chilled from engaging in conduct that is currently constitutionally protected because of the fear that it won't be later. And they'll be stuck with damages.
I mean, that's true, Irv, but it's a pretty big caveat, right? Think about labor unions taking fees while the Friedrichs litigation is going on. Think about gun stores and restrictions now with, as Roman said, sort of the unsettled nature of the Second Amendment. I mean, you're right, but I still think there's a lot of opportunity for mischief in various areas of the law. And just to go to Greg's question, I haven't thought about it a lot, but it seems like class certification or provisional class certification is one potential answer. The problem, at least as I understand it, I haven't dug into what Paul has, is that the district can't go on to do those proceedings because when it ruled against the immunity for the governmental defendants and they went up to the Fifth Circuit then stayed things from going on in the district court. So it's not that you couldn't certify a class and maybe then get to broader relief. It's just the district court can't do anything right now, at least as I understand it. But I, like I said, maybe I'm wrong about that.
So you're talking about a defendant class or something, a class of all people who might enforce the law or something like that?
Yeah, I mean, what if one of these people who wants to sue against the law sues as a class or putative class representative? I mean, why these two individuals who have sued now, why can't they sue on behalf of all other people in the state as a putative class? There may be something in the law about that. Maybe it doesn't allow class proceedings. I don't know, but why bring an individual suit? If you're going to sue, why not bring a putative class and bind everybody? I don't know. There's probably a good answer to that.
It is a bizarre procedural knot, the whole thing.
Does anybody know, does the Texas law not allow class proceedings? I mean, it would be clever if it didn't. I just don't know.
I don't know.
So I think the problem is getting the first person in, right? Who, as a defendant, who's going to declare an intent to enforce the law. You've got to get one named defendant in.
Now we have people who have people who have sued, right? So you can sue them.
Yeah.
Well, you've got the guy who's already provided, right? And now he's been sued by individuals. Why don't they bring a putative class for damages on behalf of everybody who can sue the abortion provider? Just a class action for damages. And then that goes up and it binds everybody, I think. But
so you're talking about a state class action. I thought you were talking about a federal class action against the defendant class of people who could be enforcers.
You could try to do it either way. We'll do both.
So Greg, we've really answered this question well.
Yeah.
Do we have another question?
Yes, we do. I'd like to recognize Robert Barnes from the Washington Post.
Hi, you guys were doing great until that last answer. I'm wondering if the other panelists could address what Irv said at the beginning of this, that he sees this as a turning point, perhaps, for the court's legitimacy. And what we have seen from justices in the last week or two is their recognition of the trouble, perhaps, that the court is in.
I mean, I'm happy to jump in a little bit. I do think there's a sustained campaign to delegitimize the court that has gotten, some traction on the left. I mean, you can just see it if you take President Biden as a kind of bellwether. I mean, he was someone who was always very strongly and clearly against things like court packing. And then in the pressures of the campaign, he basically had to commit to taking a close look at that and sort of backing off of his other stance. The vice president has talked about impeaching Justice Kavanaugh as a candidate. I don't know if she still holds, when she was a candidate, I don't know if she still holds that view. And so I think there is a sustained delegitimization campaign. And as a result of that, you see, the poll numbers moving. And so I think that is real. And I think, frankly, the court, to its credit, is defending itself, and it's defending itself in a way that spans what some would see as the ideological or partisan divide in terms of, the appointing presidents. I just finished Justice Breyer's book, which I thought was, frankly, pretty courageous thing to do, to come out with a book like that was defending the court and taking a longer term view, and saying things that people on his side, who would be thought to be on his side, aren't going to like. So I do think that there is some danger there for the court. I hope that the court's response to that is not to, I don't think judges in general should be, listening to public opinion and tailoring their rulings accordingly. But obviously there are people out there who think that they can influence justices by taking to the streets and doing politics, and hopefully they're not right, but we'll have to see.
We do have a series of events that have contributed to this, and it's not just a sort of manufactured campaign. That the thing that the campaign can use is the fact that the court is going to be way to the right of the American people on a lot of issues, and it got there by virtue of the Garland situation and the Barrett situation. Democrats have won the popular presidential votes seven out of the last 8 times, and they still don't get any Supreme Court nominations. So there are a lot of people who are very upset about how we got here, and that can then be used when you combine it with what look like Supreme Court decisions that are going to be overruling lots of other decisions over time. Maybe they'll do it slowly. That I don't think this felt concern about the court having jumped the tracks and gone illegitimate is going to go away. In part of that, I'm sure you're right, Ramon, is that there are people for whom this seems like something they want to keep alive. But a lot of people are getting there on their own just by the series of events that have produced this court.
Yeah, I think that's fair, Paul. I do think that there is an effort, though, to take those events and to spin them in a way that is, designed to delegitimize the court. For example, and I have enormous respect for Attorney General Garland and, previously Judge Garland. And as I've said before, if I were a Democratic president, he'd be at the top of my list. But, characterizing what happened with his nomination as stealing a Supreme Court seat, I think seems like overheated rhetoric. People rightly condemn that rhetoric when you're talking about someone else stealing a presidential election, in my view. I don't think it's any different when you're talking about stealing a Supreme Court seat, when in fact, the Constitution has a procedure that's in place and the votes were not there. And again, I say that with enormous respect for Attorney General Garland. And so I think that kind of effort of using, that kind of incendiary language, if you repeat it over and over again, it does have an effect on people. I also think, as I think maybe it was Jeff or maybe Irv noted earlier, if you look at the track record of the court, even the last couple of years, you see in a lot of these cases over and over again, very dire predictions of what the court is going to do because it's so partisan. I mean, we saw in the Kavanaugh hearing and the Barrett hearings, even in the Gorsuch hearing, the prediction was made that the reason these individuals were being put on the court was because they were going to hand the election to Donald Trump, they were going to shield him from investigation, and they were going to overturn Obamacare. And none of those things came to pass. And in fact, I think if you talk to people on the right who are more on the political side of things, you will see a lot of frustration with the court that the idea that they haven't acted in a way that the politics would suggest. And so I take your point, and I agree with your bottom line that this concerns are not going to go away. And I understand why people are unhappy with the current composition of the court if they don't agree with the results that they're getting. But I do think that it is it's an unfortunate, commentary on our politics that disagreeing with the court is going to lead to an effort to delegitimize it. And I think that has potentially long-term negative consequences for the independence of the judiciary, especially if it leads to a situation where we're talking about court packing.
The only thing I would push back a little bit on, Ramon, is the one area in which the conservative majority on the court has not held back and has not been divided, it's not gone 3-3-3, is on any case involving elections. every single case, and I include the two that were decided in June, always end up favoring their political side. And that's in campaign finance, it's partisan gerrymandering, it's the Voting Rights Act, which has now been made almost inoperable. So this is an area where I think a lot of people think that there is politics at play, and that feeds into it. So I would just note that. You're certainly right that a lot of the other stuff about like Obamacare and everything was overheated rhetoric in the first place, and the court did not go there, which was a good thing.
I do think I take your point, Paul, on the election cases. I do think there is an very important caveat to that, which is, you had a number of cases that tried to get to the court in the context of the recent presidential election, and the court completely stayed out of it, even though that I think was the most high profile partisan effort to bring the court into politics by influencing elections that you could thought of. And I think
the post-election cases were pretty ludicrous, but yeah, they didn't do that. I'll give them credit for that.
And I think that right. But anyway, I take your point. I think, look, I'm not trying to say that on every issue the court's going to go slow. I definitely don't. I'm not saying that. So I think you're right to point to those cases as an area where there's been less sort of nuance and internal division.
Yeah.
So Nicole has to leave us, and I assume the rest of the crew is we're past time. So
Irv, can we take one more question?
One more question we'll take.
Nina Totenberg, I believe you are unmuted.
Finally, can you hear me?
Yes.
Okay. So after that very heated exchange in the end, let me go back to affirmative action for a minute. If what the court does is not directly overturn Rudder, but it makes it practically impossible, and it does that in a case involving Harvard, which has always been the gold standard since Justice Powell's opinion for the right kind of affirmative action, isn't the PR effect for the court? I don't care about how you all can justify it as different, but for the court, isn't the PR effect the same as if they had overturned it?
Anybody want to weigh in on this one? I feel like Jeff, you should say something here.
Nina, I don't necessarily think so. I don't think it's as much of a story if they just rule against it in a way that makes it harder for colleges and universities to take account of race without, at least in theory, taking it off the table altogether. But I also have to say that, kind of going back to Bob's question earlier, it seems to me that this all rises and falls on Dobbs. If the court actually is prepared to overrule Roe and Casey, what it does on guns and affirmative action will be, relatively minor wind in the sails. And if it's not prepared to overrule Roe and Casey, it seems to me what it does on some of these other issues is also not going to be strong wind in the sails with respect to PR or legitimacy or whatever you want to say. If they strike down affirmative action, however they do it, and they somewhat expand the Second Amendment right by taking New York's fairly outlier system and allowing it, I still don't think that's going to create some kind of groundswell with the public unless it's accompanied by some kind of a watershed ruling on abortion. It's just like what the point Roman made, right? Everybody said, if you confirm Judge Barrett, she and the conservatives are going to join to strike down the ACA. And once they didn't, it took the wind out of those sails, even though there were some other rulings last term that were fairly conservative, but it lost all steam. And I think the steam on this is last year it was the ACA, and this year it's Dobbs. And that determines, I think, what the narrative is for the court. That's my own personal view. But I'd be curious if Paul or Nicole has a different reaction.
Others on speaking to the effect?
I guess I think if they take the Harvard case, they're going to overrule Rudder. So it's hard to imagine that they won't. But whether I'm not sure if I agree with Jeff entirely that wouldn't have a pretty major impact on people's perception of the court. But it is true, I think, that it would be additive to a major abortion ruling, and without the major abortion ruling, they could get past it.
So thank you, everyone, for being here and participating. The panel, thanks a bunch. And we'll look forward to next year in person.
Thanks,
Thank you.
everyone.
So,
Bye, everyone.